Right, good morning everybody. I'm hoping that you are receiving us loud and clear. It's a pleasure to welcome you this morning to our employment webinar, and apologies to those of you who are hoping to join us in person in the office. For various reasons we felt it might work better if we had this entirely online. For those of you who don't know me, my name's Anne Pritam. I'm a partner in the employment team, and I also work in partnership law, and I head up our UK inbound immigration team. This morning we have 4 speakers whom I will introduce in a moment, but before that I just wanted to take the opportunity, while we have so many friends of the firm present on this call, to say a farewell to Kate Brearley, who will be leaving us at the end of April. It's a little bit premature, but as I say, we're all gathered today, so wanted to say it in person. Kate has been a true inspiration to so many of us, myself included. She's the reason I moved from my previous firm to this firm. She's an astonishingly accomplished lawyer. Even for those of you who haven't worked with her day to day, you will know her probably from some of these seminars, and in particular from her really unrivaled expertise in the area of restrictive covenants, and she co-wrote the leading practitioner's textbook on it. We are going to miss Kate enormously. She's leaving us some metaphorically big shoes to fill, because her own feet are not that large. But we all very much look forward to carrying on her legacy. Hopefully you'll stay in touch with us. And as the founder of the Stephenson Harwood employment team, we owe her a special debt of gratitude that we are here today in the strength of numbers that we are, and with all of you knowing us and working with us day to day. So good luck to Kate when the moment comes. I'm sure many of you will be in touch with her anyway, but I wanted to say a sort of proper thank you and farewell on this call. So this morning, to today's business, we have 5 speakers. We have Richard Freedman, a rising star in our team, who will be covering developments in the law. We'll have Katie Hewson, who is also a partner, but she is not in the employment team. Katie is actually in our data protection team, and she'll be talking about data protection related issues. We have with us Marta Garcia, a face that may be new to many of you, but who has been with us for many years, who's a competition law specialist in our corporate team, a partner there. And Marta will be speaking about the rather unusual interface between employment issues and competition law. So for those of you in HR who thought you didn't need to know about it, it's worth listening to Marta. She's got a few hints. And finally, we have Imogen and Serena doing a look forward and look back in terms of what's been going on in the law. Welcoming Serena back, incidentally, from maternity leave, for those of you who haven't seen her for a little while. So I'm going to hand over to Richard so we don't lose any more time. And I just want to let you know, firstly, that we are very happy to take questions, but we'll do it right at the end. As you can imagine, there's a lot of material to cover, but I'll be speaking back at the end. I'll be back then. If you've got questions, please put them into the Q&A section on the Ring Central app, and I'll be watching those, and we'll pick up as many as I possibly can when all the speakers are finished. So over to you, Richard. Thank you.
Thank you, Anne. Morning, everyone. Yes, so I'm going to speak with you about behaviour in the workplace. If we can just move on to the next slide for that, please, and then one more. Thank you. So here we've got a number of headlines on this slide, essentially with the intention of grabbing your attention, or at least hopefully doing so, but just to demonstrate what inappropriate behaviour can result in. Namely, in this case, a number of headlines that employers would not want to be associated with. And it's worth mentioning that all of these headlines are relatively recent. They are all post-Me Too era, all post the really globalization of the Black Lives Matters movement. So they clearly demonstrate that inappropriate behaviour in the workplace is still very much an issue, and still very much something which grabs attention by the press. And as I say, it's certainly not something that employers would want associated with their own organisations. So moving on to the next slide. As many of you will know, if inappropriate behaviour is linked to a protected characteristic, then it is likely, or at least possibly, going to be some form of unlawful discrimination. Now, I won't go through each of these protected characteristics, as many of you will be familiar with them already, but it is, of course, worth being aware, as I say, that if inappropriate behaviour is linked to these protected characteristics, then there is a very material risk of discrimination type issues. So, what are the different forms and types of discrimination? Now, on the next slide, we will go through these. And again, some of you will be familiar with these, or at least some of them. Direct discrimination, I suspect, is the one that is most obvious, and many of you will be familiar with. This is where you treat an employee less favourably than someone else because of a protected characteristic, so their age, sex, race, sexual orientation. If you do that, then that is direct discrimination. So, for example, not inviting a female colleague to a client event which is taking place at a football match because they are a woman when you've invited all your male colleagues. Then moving on to indirect discrimination, slightly more nuanced. This is where you apply a policy, criterion, or practice to you apply it neutrally to a range of people, but that policy, criterion, or practice disadvantages a group sharing a particular protected characteristic. For example, if your team socials always require a lot of alcohol drinking or any alcohol drinking, then this may indirectly discriminate against people who hold a religious belief, which means they don't drink alcohol, or against pregnant women, or people who have health conditions which require they don't drink alcohol. So on the face of it, it's apparently a neutral practice because you invite everyone, but because it disadvantages people holding a certain protected characteristic, that can mean that it can be indirect discrimination. Then moving on to the third bullet point on this first heading, discrimination by association or perception. And these are ones which, certainly discrimination by association is perhaps a less obvious type of unlawful discrimination. But it is where you discriminate against someone because they are associated with someone with a protected characteristic. So if you treat someone less favourably because their spouse is of a certain nationality or ethnicity, or sometimes we see this where there is discrimination because an employee has caring responsibilities for a disabled relative. That's the type of situation where you need to be live of the possibility of discrimination by association. And discrimination by perception is pretty much exactly what it says on the tin. It's where you discriminate against someone because you perceive they have a protected characteristic, even if they don't necessarily hold that protected characteristic. It's enough that they are perceived to do so. Moving on to harassment, this is unwanted conduct which has the purpose or effect of either violating someone's dignity or creating an intimidating, hostile, degrading, or offensive environment, and is linked to a protected characteristic. There is also sexual harassment, which falls within this heading as well. And it's really important to note that even if it's not intended, the behaviour is not intended to have that effect, it can still be harassment. It is really a question of what the person who's being harassed believes. If they feel that it creates the type of environment just mentioned, then it's likely to be harassment, provided it is reasonable for the conduct in question to have that effect. So if it is completely unreasonable for someone to say that an environment or type of behaviour is creating an intimidating environment, it won't be harassment if it is completely unreasonable for the conduct to have that effect. But that is obviously not. You don't really want to get into the grounds of that argument if you can avoid it. And of course, it's important, and I'll touch on this a bit more later, to be aware that actually people can be harassed by behaviour even if that behaviour is not aimed at them. So if there are jokes being shared between colleagues, they are inappropriate jokes, then even if those individuals are not offended by, or those jokes are not creating an offensive environment, a third employee who is not party to the jokes but who can hear them could be harassed by that behaviour, even if they are not the intended subject of the jokes. Now, there is a possible defence for employers around harassment if they have taken all reasonable steps to prevent harassment, or prevent harassment. But be warned, that is an extremely high bar. It's unlikely to be ticked just as a result of sending employees on some behaviour in the workplace training, for example. It is a very, very high bar to satisfy that defence. Moving on to victimisation. This is essentially similar to retaliation. It's essentially where an employee is penalised, either by being subjected to a detriment or by being dismissed as a result of raising a complaint or assisting another in relation to some form of discrimination complaint or claim. And what's really important to note is an individual can be victimised against even if their complaint is not proven. So if they believed there was discrimination ongoing and they made a complaint, then they have victimization protection, even if that complaint is not proven. There is a slight difference there if for example, the complaint in the first place was not in good faith, but simply because an allegation is not correct does not mean, or is not proven, does not mean that you do not have victimization protection. And a number of us in our team have seen issues arise for employers where through victimization, even if the initial complaints upon which the victimization claims are hooked onto, even if the initial claims or allegations are not well founded. It's also important to be aware that individual employees can be personally liable for acts of discrimination. And this is something we see more and more, where claimants bring claims of discrimination not only against their employer, but also against their line manager or any other individual employees who are alleged protagonists. That obviously is a concern for all employees, as it should be, but I think what it does do is it's quite a helpful tool when you are training staff, quite a helpful tool in getting employees and managers' minds focus on this topic. It's amazing how much more focus people seem to get once they realise they can be personally liable for issues. So clearly, it's not something we want any of your employees to be on the hook for. But I say, from a training point of view, it can actually be a useful tool of getting people to buy into the reason for this training, this type of training. So moving on to the next slide. Obviously, I think we're all familiar with the idea that things like banter is not going to be a good excuse anymore. Not going to, if it ever was, not going to get you off the hook for any claims. I think now what we are seeing is more types of slightly more nuanced behaviour, slightly less obvious behaviour being the foundation of claims. And a couple of those types of behaviour are unconscious bias and microaggressions. In brief, unconscious bias is where, or relates to stereotypes people hold about other groups, often outside their own social awareness, but which still affect our thought process, especially when we're making quick decisions under pressure, which I'm sure many of you do. And really, as a result of having to make those quick decisions under pressure, people don't have the time to think about perhaps the unconscious bias that is affecting those decisions. A good example of where that can come into practice is things like recruitment or work allocation. People often go with what they know. I think to some degree it's human nature, but what that can result in is essentially decisions around recruitment. Sorry, I think I've got a bit of feedback there. Decisions around recruitment or work allocation being made in favour of people who you share a common background with. And obviously that can result in unconscious bias against people of a different ethnicity, for example. Microaggressions, similarly, they are verbal, behavioural or environmental indignities, again, whether intentional or unintentional, which can create a hostile or intimidating environment. And just looking at this slide, there are some examples of unconscious biases and microaggressions. So commenting with surprise on an Asian employee's articulateness, consistently asking female employees to pour coffee or take notes, mansplaining or speaking over women in meetings, repeatedly asking an employee from a different ethnic background where they are from, or talking about shared interests to the exclusions of others. I think a couple of points on this. I think one, when you stop and think about these things, I think you can see how they could exclude people from different backgrounds. As I say, it's often these issues arise when people are making quick decisions under pressure without having the opportunity to think about things. What really you want to be doing is encouraging your staff and training people so actually they do have these things at the forefront of their mind, so they are thinking about them, so there's less chance of people applying these unconscious biases simply because they are no longer unconscious. I should also flag, this is not me saying you cannot talk about shared interests at work. It's not me saying you can never talk about football, golf, cricket, whatever. Of course you can. It's simply explaining that you need to be aware of doing so or consistently doing so, which results in the exclusion of other team members. And just at the bottom of the slide, just a point here around data subject access requests. Always worth remembering and having your staff remember that actually information written down about people may be retrievable as part of a data subject access request. And I think the simple answer is be careful what is put in writing. Moving on to the next page, and this is something I'll talk for the rest of my talk about investigations. It also gives me the chance to touch briefly on county cricket, which mentioning previously, talking about topics to the exclusion of others is something I don't have an issue with, even though I try at work, but it does give me an opportunity to touch on county cricket. So Adil Rashid, as many of you will know, or some of you may know, was a county cricketer with Yorkshire in the last decade over 2 spells. Following his second spell, he raised a number of complaints around his treatment at Yorkshire, including making 43 allegations of bullying and essentially racial discrimination. He alleged that there was Yorkshire County Cricket Club was essentially institutionally racist. Now, what transpired as a result of those allegations is a great example of why it is important for organisations to investigate matters appropriately. So what did Yorkshire do? Well, originally it looked like they were doing the right thing. They appointed an independent law firm to carry out an investigation into these allegations. But essentially that is potentially where the issue started to arise. That investigation took an extremely long time, well over a year, and obviously essentially created a vacuum of concern that itself started to grab press attention. Now, finally, once the investigation was completed and the investigation report was fed back to Yorkshire, what it found was that 7 of the 43 allegations of bullying and or race discrimination were upheld. But what Yorkshire determined was that actually, even though 7 allegations of bullying and or discrimination were upheld, they said we are not going to take any action against any employees because essentially they didn't feel it was necessary, and also they queried Rafiq's behaviour. Now, they went even further than that and essentially said that if Rafiq was still an employee of the cricket club, he himself would be subject to disciplinary action. So that links to the topic of victimisation. Essentially, you are turning and retaliating on an individual potentially for raising complaints. And it was those comments against the background of Yorkshire also saying, well, we are not going to take any action against any individuals, even though we've upheld a number of allegations made by Rafiq. And one of the reasons they said they didn't want to or didn't need to was because actually the behaviour in question was friendly and good-natured banter. Certainly not something that employment tribunals give much time to. Now, that investigation and that outcome has led to some serious repercussions for Yorkshire County Cricket Club. And again, these are a good example of why it's so important for employers to deal with matters appropriately. They've had a number of significant sponsors withdraw, including their stadium sponsorship. Their chairman has resigned. Other board members have stepped down. Subsequently, there have been a number of dismissals, and they're now facing a number of employment tribunal claims as a result. And also the England and Wales Cricket Board has essentially withdrawn the right for Yorkshire to hold international cricket for the next couple of years. There's some discussion about whether or not that's going to be reinstated at the moment, but so far it's been withdrawn. And also they've had a lot of adverse press. Now, this has resulted in millions of pounds loss for Yorkshire, which is a huge sum of money for any organisation. And it just shows the potential impact of not dealing with these matters appropriately. So, moving on to the next page, we'll talk on the next slide, sorry. How should organisations conduct investigations properly? Well, firstly, you want to have proper policies and procedures in place, and where applicable, they should be ACAS compliant. You want to be acting promptly. As I just said, with Yorkshire, one of the issues was actually a very, very long delay in that process. Unnecessary delay may well cause memories to fade or give perception of an unfair process. You need to focus on what the purpose of the investigation is. So consider what is required to be investigated. Is a recommendation required? How should the investigator report their findings? Who should they report their findings to? And also, whilst there shouldn't be unnecessary delay, it should be sufficient such that the investigation is fair and reasonable. And again, link back to any policies. You know, is there a timescale in your policies that you need to comply with? Is that timescale in the policy appropriate? Does the policy need to be looking at the appropriate time in the future? And remember that investigations are a fact-finding exercise to collect as much information on the issues as possible. A decision on any grievance or complaint is going to be very difficult to justify if a proper investigation has not been undertaken. Next, consider who should investigate. You'll need to take into account obviously the individuals involved, the seriousness and complexity of the matter, and the nature of the grievance. And you want, again, to make sure that the person or the pool of people who you could appoint to investigate have been appropriately trained to carry out such investigations. And obviously, when a grievance is raised, it's too late or it's often too late to have that training carried out, which again shows the importance of making sure the relevant people are trained appropriately at all times. Investigatory meetings, you will need to consider who you need to meet with or who needs to be met with. Very, very likely that it will be the person making the complaint and also the alleged perpetrator. You want to meet with the person who is making the complaint at an early stage, because that will help you establish the issues surrounding the grievance, and again also help you decide who else you need to meet with as part of the grievance. In addition to simply carrying out meetings with people, is there any other evidence that you may be able to obtain which may be relevant? For example, is there any CCTV footage that could be relevant? Do you need to look into any IT records that could support or otherwise refute the allegations? So it's not simply a case of meeting with people and thinking that's job done. Consider what other evidence there may be. And then it's ordinarily good practice for the investigator to submit a written investigation report which sets out the scope of their investigation, the process that they've undertaken, and also their findings. And then finally, confidentiality. Clearly, it's very important for matters to be dealt with as confidentially as possible. One of the reasons being that generally you want to encourage a culture of where people can raise issues so that they can be dealt with, and the culture of the organisation is improved as a result of that if it needs improving. People are much more likely to feel like they can raise issues if matters are dealt with confidentially and appropriately. And that should be reiterated to people throughout the investigatory process. So people who you are interviewing, make sure they are aware that actually all matters should be treated confidentially, and potentially that if there is a breach of that confidence, that could be dealt with as a disciplinary matter. Okay, that's all from me. Thank you very much. I'm going to hand you over to Katie now on the data protection side.
Hi everyone, I'm Katie Hewson. I'm a data protection partner at Stephenson Harwood, and I'm talking today about possible changes ahead in the data subject access request regime. We thought this might be of particular interest to employers because we know from experience they can cause a huge headache in the employment context. And there is some exciting news on the horizon in that the government is looking at data protection law and looking in particular at data subject access requests. Can I have the next slide, please? So the consultation that I'm talking about is DCMS consultation. It's called Data A New Direction, and it's part of the sort of post-Brexit proposals that the government is making to move the data protection regime to some extent away from the EU GDPR and to kind of encourage innovation. They're making lots of wider changes potentially to data protection law. So for example, they are proposing changing the need to carry out data protection impact assessments, to appoint data protection officers. They are looking at new ways of safeguarding international data flows, and generally trying to encourage research and reduce barriers to kind of using data in lots of different ways. In an employment context, I know the kind of the DSARs are particularly cumbersome, and the DSAR proposals in the consultation are actually fairly eye-catching. So just to kind of go through what the key points are, but before we do that, I suppose I should just say where we are with the consultation. The paper was published in November. The responses, and many responses have come in, so they're currently being analysed. So this is not set in stone yet. The government is going to produce a response in the next couple of months, and then it's going to be moving to produce a white paper, but it won't be for sort of a year or so that we actually see potential legislative change on this. So these are changes on the horizon, but I suppose what I would point out is that in the meantime, if you're dealing with a subject access request and you can see the kind of direction of travel, I would have thought that the ICO would be less likely to take enforcement action on the basis of something that's about to change and kind of become less cumbersome anyway. So it's worth bearing in mind even before the changes are necessarily immediately introduced. So the consultation notes that organisations, employers in particular, are being overburdened by wide-ranging and speculative DSARs. And they make two key proposals to try and make employers' life easier. They are reducing the burden of DSARs on organisations and introducing a lower bar to actually refusing certain DSARs. It's not going to be a complete free-for-all, but there is a bit of light at the end of the tunnel on them. So reducing the burden, what are they thinking about and how are they thinking about doing that? There are two key proposals here. One of them is to reintroduce the old nominal fee regime that we had. I don't know how many of you were dealing with DSARs under the 98 Act, but we had a £10 fee at that stage for making a subject access request. The idea wasn't to cover any costs. Clearly, we all know they cost a lot more than that. but it was just to kind of introduce a sort of little hurdle so that people thought twice before making a subject access request, and made sure it was a sort of serious thing rather than a flippant way of trying to annoy a company when you had no interest in getting your data. And it's interesting, it's only a small amount, I suppose, but we did see a big rise in subject access requests once that fee was removed. So the possibility of having this fee reintroduced, and we don't know if it would be £10 or a different amount, there's no information on that, but the possibility of having this nominal fee again might have an impact in terms of numbers of subject access requests. I suppose this is going to be fairly controversial. It's not maybe much money, but at the same time, it is a sort of fundamental right. In theory, to get your data, you should be able to see what an organisation has on you. Certainly some of the kind of bigger, more powerful organisations in terms of data, so the kind of Facebooks and Googles of this world, you could see there being some pushback as to having barriers to getting your data from them. But it might be that there's a sort of dual regime where certain organisations are allowed to charge a fee and certain organisations are not. But let's see where we end up on that. It's certainly one to watch. There is the other way of that the government is looking at reducing the burden is to introduce the concept that we haven't had before in data protection, DSAR's context, of a cost ceiling. So I don't know how many of you are familiar with the Freedom of Information Act, but looking to this for clues, they have this cost ceiling concept where someone makes a request for information from a public authority. Because we don't have many details on what the amount of this would be or how this would quite work. I've looked through FOIA for some sort of clues on it. And the Freedom of Information regime, it sets a cost limit of £600 for central government and £450 for other public authorities. So if a request is more than those ceilings, you can refuse to deal with it or choose to charge the requester the extra. You're not usually entitled to just throw the request out completely. What the public authority and under the FOIA regime would normally be expected to do is to still deal with the request, but you wouldn't have to spend more than the cost limit. So maybe narrowing the scope, doing what you can within the limit rather than just completely getting rid of it. So this is broadly what's planned for subject access requests. We don't know what financial limits would be set, and we don't know whether this is actually going to go through. But it would be a really promising step for employers if there were some form of maximum spend that you would have to actually make for each DSAR, because I know they can get expensive and no one wants to spend money on them. I suppose just a few notes of caution and learning from the Freedom of Information regime. It's not you'd only have to spend the limit and that's it. If you look at what FOIA says on the cost limits, you can only take certain tasks into account. So for calculating whether you've hit the cost limit, you can look at whether, determining whether information is held and retrieving and extracting it, but you can't, for example, take into account time taken to consider exemptions. So not all of the things that you will be doing to respond to a DSAR will necessarily counts towards that cost limit. And the cost limit for FOIA is quite prescriptive in terms of it gives an hourly rate that you're allowed to use to kind of go towards to calculate whether you've hit this limit, and it's £25 an hour normally for government. We all know, that lawyers do charge a lot more than that, but it's interesting to see whether there is a kind of equivalent hourly rate that you have to apply, and you can't apply any more than that, even if your costs in reality are a lot higher. So again, a note of caution, it might end up that the cost limit doesn't reflect the kind of likely true cost of complying with the DSAR for your business, but at least there will be some form of cap on it for you. The other area that the government is looking to reduce the burden for DSARs is in introducing a new means of refusing requests entirely, which I know will be good news to many of you. At the moment, as you know, we've got a quite high bar for refusing requests. It's if those requests are manifestly unfounded or manifestly excessive. And that word manifestly does quite a lot of heavy lifting. It has to really be clear on the face of it that someone just does not want to access their data, or just really wants to cause a nuisance. And just because you suspect that in the context isn't usually good enough reason if there's no clear evidence of it from what you've seen from the requester. So it's difficult to refuse requests entirely at the moment. The government is looking to, again, inspired by FOIA, to introduce a vexatiousness means of refusing DSAR. So again, it's quite vague on the detail of what this would mean. So I'm looking to FOIA for clues. Under FOIA, you're allowed to, as a public authority, refuse an information request if it's likely to cause a disproportionate or unjustifiable level of distress, disruption, or irritation. It's a lower threshold than something that's manifestly unfounded or excessive. So ICO guidance on vexatiousness indicates that a public authority can take into account the context and the history of the request, and the requester's identity and the previous contact that you've had with them. So again, you're allowed to kind of take into account if there's a contentious employment situation, it could well be that that context is allowed to be more relevant than it currently is, whereby at the moment you're supposed to be sort of motive blind and context blind. So it might well be that it makes it easier in future to refuse a request entirely on the basis it's vexatious. So that's certainly one to watch in terms of how that's actually carried through in reality. Can I have the next slide, please? So just a few points then on what's actually the kind of wider context, because obviously it's very important what the ICO has said in response to this consultation, especially if you're dealing with DSARs in between now and when the new law gets introduced. And that's obviously because if you're dealing with the ICO, you're going to want to know what their kind of appetite for going along with these changes is, if they're the ones potentially introducing enforcement action against you. They published, it was a sort of fairly neutral response to the DSAR's points. It pointed out that it needed more information from the government about how the proposals be balanced against the rights of individuals. And it clearly sees that there's potentially a threat to individuals' rights if people genuinely want to exercise their right to get hold of data. So it's concerned to make sure that rights are upheld, but it's not completely opposed to the idea of a nominal fee, for example. It's not ruled that out. It's not said it would oppose that. It did point out, obviously, there's potential for discrimination if people have limited financial means. Potentially, they would be less able to get hold of their data, and that doesn't feel right in terms of the fact that you should have a right to your data. So how that would be got around, I don't know, but that's clearly an important issue, and it means it's quite a controversial one. The ICO did point out that you shouldn't just lift and shift sort of FOIA provisions into the data subject access requests. It pointed out there were differences between, there are important differences between subject access and FOIA. I suppose that the ICO's most important point is that in theory, we all know sometimes they're used as a nuisance, but in theory, data protection and data subject access requests offer information that actually could have a profound impact on someone's life. Freedom of information is generally people worried about the sort of local drains, but actually personal data, some of the kind of data that people could be potentially be asking for from employers could have a really important impact on their wider life and their employment. So they're very cautious about just about importing the FOIA regime completely. So it's not necessarily going to be very closely aligned to how FOIA works. The ICO also, I suppose, raised the issue that there is a disparity in cost between appealing a freedom of information request that's free whereas to actually challenge data subject access request response, you can make a complaint, but otherwise you have to actually go to court, which entails more money on lawyers. So again, they're a bit cautious on just withholding people's rights entirely. So, you know, a mixed response, but we'll see where we get to as the kind of consultation response is published in the next couple of months. I suppose I should introduce another note of caution. It's that if your organisation, and I know many of our clients are dual regulated and they're subject to the EU GDPR as well as the UK GDPR, if you are subject to both regimes, you are still going to obviously have to comply with the EU GDPR too, potentially depending on the facts of a particular subject access request. It might be that it falls under both versions of the GDPR, and it's no good really being able to refuse it under the UK version if you're going to have to respond anyway to the EU version. So it's not going to be plain sailing on that front. I suppose the other note of caution is that if we go too far, and it's obviously not just subject access request related, but if we go too far and diverge too far from the EU GDPR in our wider changes to our data protection regime, if this could see the EU look at and possibly even remove, in worst case, our UK adequacy decision that we have from the European Commission. And that has the potential to really disrupt data flows between the EU and the UK. And there would be a far higher cost to business to kind of papering those data flows and putting safeguards in place where there previously were none needed than the cost of DSARs. So the government needs to kind of toe quite a fine line between freeing up and you know, reducing the burdens on business and actually accidentally introducing more burdens if his adequacy decision does get revoked. So that's again an important factor. The ICO's response, just a couple of final points on that. They point to some alternatives to the consultation proposals from the government. I suppose they talk about, it's interesting, they talk about tools that could be used to lower the costs of subject access request responses. So management dashboards and access portals. I don't know, I know some of our clients are using these kind of automated ways of actually receiving subject access requests and then, you know, searching for data and mapping data and actually lowering the cost of doing it by sort of doing a lot of it automatically. The ICO is seemingly very encouraging of this, and it sees this as a good way of lowering costs in the long term, rather than necessarily refusing requests entirely. So that's an area to watch. It could become more of an expectation from the regulator that you have some systems in place, depending on, I suppose, how sophisticated an organisation you are. We do have systems actually that we can use to help clients deal with DSARs automatically, but it could well be that more organisations actually start to have them in-house. The ICO also points out that you can't sort of use poor record keeping and poor information management practices as an excuse for a poor or delayed or costly response to a DSAR. So it won't see the cost ceiling as a way of getting out of your obligation to actually keep your records in good order and make sure you're not keeping too much personal data in the first place. So that's the latest from the ICO, and that's all I wanted to say on DSARs for today. And I'm going to hand over to Marta to talk about competition law in an employment context.
Thank you, Katie. So I'm Marta Garcia. I'm a competition partner here at Stephenson Harwood, and I wanted to talk to you today about really the increasing scrutiny that we're seeing by competition authorities of certain practices in labour markets, and what it is really HR professionals should have a basic understanding of, given the significant potential consequences for corporates and individuals if they're found to be in breach of the competition rules, and that's namely hefty fines, void and unenforceable contracts, even criminal sanctions such as imprisonment and director disqualification orders. So if we turn to the next slide. Briefly, by way of background, really the focus of antitrust enforcement has traditionally been on price fixing, market sharing, but in the context of sales markets, so that's goods and services, with labour markets really being relatively untouched. But over the years, what we are seeing is a real growing recognition that antitrust rules do have a role to play in labour markets, and that really companies should have to compete for workers just like they compete for customers and products and services. So the same antitrust rules should apply. And indeed, especially post-Brexit and COVID as well, there has been and continues to be a focus really to try and support the economic recovery and boost innovation and competition by increasing mobility in labour markets and preventing stagnation of earnings. The view being that if there's greater competition among employers, this helps employees through better wages and better benefits. There are more competitive, happy workforce, which leads to greater innovation, more and better goods in the market and for consumers ultimately. So any practices that operate against these objectives, especially if they're entered into by competing operations, are really frowned upon by the antitrust authorities and in effect treated as cartels, which are the most serious breach of the competition rules and lead to hefty fines. If we turn to the next slide. So what we have been seeing is that really the most significant antitrust civil and criminal enforcement in labour markets has been and will continue to be for some time in the US. They remain the highest risk jurisdiction from an enforcement standpoint, and there have been very clear statements about how protections for employees are key and that any anti-competitive agreements entered into by competitors should be treated as criminal cartel activity. And as I'll go on to mention, many other countries now worldwide, including here in Europe, are now taking a very similar approach to the US. So what are these practices then that are raising the most concern and that HR professionals really should know about? So firstly, antitrust authorities are becoming very concerned about wage fixing agreements that may be entered into by competing organisations. So these are agreements between competitors as to how much to pay employees, any capping or withholding of pay rises or any bonuses, aspects like that. The view really being that a competitor should set their pay strategy independently and not together with another competitor in the marketplace. And these really are considered almost automatically legal in most of the jurisdictions that have been looking at these types of arrangements. So equivalent to what we would consider a price fixing arrangement under the competition rules, especially given really the intention here is to really keep salaries down for employees. So that's one of the primary areas that antitrust authorities are focusing on when it comes to labour markets. If we turn now to the next slide. Regulators are also becoming increasingly concerned with what they're defining as no-poach agreements, again, entered into between competitors. And this is where competitors may agree not to hire each other's employees. And so this could extend, for example, to agreeing not to cold call employees at competing organisations, or not to hire employees from a specific organisation that they compete with for X amount of years, or not to counter offer above an initial offer for certain employees. And I guess from a company's perspective, sometimes these types of arrangements can make sense. They're trying to hold on to their own talent, especially if it's an industry where employees need very specialist degrees. Employers have had to fund their employees' training, and where really the employee is gaining and acquiring real specific know-how from the employer. So you can understand where that might come from. But from an antitrust authority's perspective, these arrangements really seen are as restricting the movement of employees, which can prevent career development and in effect help suppress wages. So again, this is another arrangement that we're seeing where competitors, if they do enter into them, are being viewed very negatively by the regulators. If we go to the next slide. We're also finding that even exchanges of competitively sensitive information between competitors can raise competition concerns. Now, 10 years or so ago, most authorities wouldn't really focus on this unless there was some evidence of collusion between competitors or actual real cartel agreement. But that the mood has been changing, and now here even the mere exchange of what they classify as competitively sensitive data can be an issue. The point being, it increases transparency in the marketplace and potentially gives an insight to competitors on your commercial strategy, therefore leading to less competitive markets. So in terms of what does that really mean, what are the types of information that are considered competitively sensitive? Well, those are discussions regarding issues that are here up on the slide. So the ones that give rise to the greatest potential risk from a competition law perspective are any discussions between competitors around wages and employee benefits, anything to do with suspension or reduction of salaries, or what will be awarded in terms of cash bonuses or share awards. Any discussion about perhaps the proportion or whether even employees are placed on leave or furlough or suspended from work temporarily, issues that most likely were discussed, independently by organisations during COVID-19 in particular. Discussions around compensation to be offered to furloughed employees. Do you offer a cap? Do you offer top-ups? Do you use paid leave? Issues like that, which are in effect almost considered discussions likely around price, that is considered from a normal competition perspective as problematic, is treated in a similar way. And likewise also discussions around hiring strategies, whether it's a hire freeze, offering flexible working, offering sabbaticals. These again are all matters that are considered borderline anti-competitive, and so care needs to be taken. And indeed, really, the more current and future looking the information, the more granular and the more frequent that exchange is between competitors, the more problematic that's viewed by competition authorities, and vice versa. Of course, the more historic, the more aggregated and anonymised or public that information is, the less of an issue. But it's something to bear in mind, because regulators around the world that are looking at labour markets, there is always this element of exchange of information between competitors when they decide to take enforcement action. And regulators are obviously looking at direct exchanges between competitors, but also indirect exchanges via third party, and even unilateral disclosures can be caught. And really here, just the point to note is a competitor almost is deemed to have accepted the information that is unilaterally disclosed by a competitor and use that information to their advantage, unless they respond with a clear statement that they don't want to receive that information. So just a few points to mention there on exchange of competitively sensitive information, but also obviously, hopefully we're all coming out of COVID now, but no doubt COVID did place extraordinary pressure on employers navigating the furlough schemes and other government support, trying to retain talent whilst seeing revenues and cash flows drop. And no doubt there will have been a desire by companies to talk to each other, to gather market intelligence and find out what others were doing in terms of how to approach these circumstances. But just to mention, obviously discussing certain issues like I've raised here on this slide can raise concern. And whilst the regulators have relaxed their rules to a degree and their approach during COVID, there is no COVID-19 defence to collusion in labour markets, and authorities have made clear that they will investigate practices that they feel go beyond the permitted limits of competition law. If we turn to the next slide, having covered obviously what are the key areas that the regulators are focusing on, I've mentioned obviously that the US is the leading country that seems to be taking enforcement action against these types of practices in labour markets. But I want to just make clear also that whilst there isn't yet enforcement action at the EU level by the European Commission, and we haven't seen the UK's Competition and Markets Authority either take any actual action, there is really an increased awareness across Europe, with numerous investigations already taken against no poaching and wage fixing arrangements. Spain, France, Portugal, Netherlands, Greece, Lithuania, Poland, these are all countries that have already taken actual action against companies We're seeing that in other parts of the world as well, like Canada, China, Mexico, Brazil, and really across a number of different industries. And I've highlighted just a few there, but sport, we're seeing a lot, IT, healthcare, education, automotive, even restaurant sector. So that's just something to be aware of. And here, as I say, the UK, we haven't yet seen actual enforcement action taken, but there have been recent rumours that the CMA is looking into a case that involves a transfer truce in the UK Football League clubs, which may well have limited the mobility of players. And in actual fact, the football sector seems to be one of those areas where a number of countries around the world have been looking at taking action. And we've seen that in Portugal, we've seen that in Colombia and Mexico. And what we have also seen is that even in those jurisdictions where there haven't been reported cases, there is just this changing view, this changing legal landscape to appreciating that labour markets also fall within the scope of competition law. So no doubt it will probably just be a matter of time before we see an actual case at the European Commission level or here in the UK, but it's something to watch out for because it's very prominent in a number of other jurisdictions worldwide. If we turn to the next slide. And I mention that in particular in light of certain recent statements made by certain regulators, but in particular I wanted to highlight Competition Commissioner Margrethe Vestager in her statement in October 2021, so very recently, where she made it very clear that we will be looking at atypical cartel activity, and she specifically said wage fixing and no poach agreements, and companies expect dawn raids. And she's made very clear that in her view, no poach agreements, wage fixing, that is an indirect way of keeping wages down, restricting movement, and that does not serve the economy. So really her obvious view and approach is in line with what we're seeing around the world and is consistent with that approach. And other regulators in Europe have come up with similar statements, and the UK CMA has also recognised that it may not necessarily be taking as aggressive enforcement action, or hasn't in the past, against anti-competitive behaviour compared to some other jurisdictions, but that is now going to change, especially in a post-Brexit era where the CMA wants to be seen as a very strong international player. So no doubt we'll probably see some activity to come. If we go to the next slide, obviously I've mentioned all the doom and gloom in terms of what regulators are looking at, but we do just need to bear in mind that it is very much a case-by-case analysis. Not every practice involving competitors or parties in labour markets is necessarily going to raise concern. So, for instance, non-compete provisions in the M&A context, in that sort of situation, which are imposed on the seller, which are considered directly related and necessarily to the implementation of the deal and to protect the purchaser's investment, they are typically considered not problematic. So that's just one thing to bear in mind. I'll just make a very quick point here, given we are on the topic of non-competes, and that is that obviously non-competes between employer and employee, so those that you would find in your contracts, they're not really governed by competition law. They're obviously covered by restraint of trade doctrine, as you all know. The UK government is consulting actually on whether or not to ban such non-competes to help increase mobility and improve competition. And I know my employment colleagues will touch upon this, so I'm not going to say much more than this, but the only interesting thing that we have seen in the antitrust world, and there is experience again in the US and California in particular, that when you ban such non-competes in employer-employee contracts, what you then tend to find is that employers are entering into no-poach agreements as an alternative way to try and restrict movement, mobility, and try and protect their confidential information. And so what you see in terms of changes happening in the employment context can sometimes lead to antitrust enforcement. And I think given the focus that we're seeing across Europe and across other jurisdictions on no poach, non-compete and wage fixing arrangements, it's just important to keep a watchful eye on these changes that may well come into effect, subject to the outcome of the consultation, and whether that could really have a knock-on effect in terms of what practices employers adopt, and whether that could result in increased antitrust enforcement as a result. Now, just turning to the next slide, again, just to mention some other practices that generally don't give rise to a concern from a competition perspective. That's benchmarking, especially if it's between non-competitors. That's often considered very much okay. And even between competitors, if safeguards are put in place. So, the more aggregated and anonymized the data, and if you involve more than 5 participants, typically, again, those types of arrangements involving competitors aren't considered problematic. And likewise, if you're gathering market intelligence or sharing industry views, again, on general market practice. So, for example, if we take an example, given COVID, on protection of employee health and well-being, or approach to self-distancing rules, all these matters and other pro-competitive standards that competitors may want to discuss at an industry forum, these should continue to be acceptable and encouraged. So really the focus at the moment for antitrust authorities are on wage fixing, no poach agreements, and exchange of competitively sensitive information between competitors. Now, if we turn to my final slide, I guess in the wake really of this renewed interest in labour markets, companies should assess whether their HR practices are antitrust compliant, ensure that they're not exposing themselves to any possible complaints or claims, especially given those civil and criminal consequences that I mentioned right at the start. And I think it's important really, given where we are, that companies proactively look really to audit their HR practices, especially if they're in some of those sectors that I identified, rather than just wait and see how this new wave of antitrust enforcement will play out here in the UK and at the European Commission level. So in terms of just some pointers, I think it's important to train HR professionals, managers, staff on antitrust rules that might be relevant to their practices. So, what is and isn't permissible in terms of wage fixing, no poaching, information exchange, and really update your competition compliance policies to ensure that they address labour market risks, because up till now you'll find that competition compliance policies don't really look at that, and they haven't extended to include human resource personnel. So I think that's one item organisations need to start to consider. Secondly, review agreements, ensure that they only include provisions which are within the permitted boundaries of competition law. Check recruitment and hiring practices. Is your company avoiding recruiting or hiring from specific companies? If so, why? Is it as a result of an arrangement with a competitor, or did they take that decision independently? Thirdly, I think check how you're setting employees' compensation and benefits. Again, the rule is each company should be competing independently, and if they set their package of cash compensation or other non-cash benefits independently, that's okay. But to the extent there is any agreement with a competitor on any of those aspects and what will be offered to employees, that should be discussed immediately with legal. Fourthly, make sure that those employees and folk at your organisations that attend group meetings, industry forums, are part of WhatsApp groups involving HR individuals from other competing organisations. Make sure they understand what are the limits of participating in such groups, what they cannot discuss, what they cannot agree, to limit any risk that could arise there. Because unfortunately, competition authorities, whenever they hear, oh, competitors are in the same room or talking to each other, their immediate reaction is it will be for an anti-competitive purpose. Fifthly, monitor any trends, any activity that you're seeing in the job markets. Could there be any early potential warning signs? So are you finding that certain competitors seem to have similar employee hiring practices, or are they sharing significant HR type information like I've raised? So could there be an issue there? And obviously, if you do identify any problematic conduct, analysing that carefully, taking action if you identify an issue, bring it to an end, take remediation steps to prevent it reoccurring. And if you consider that it needs to be reported to a regulator, deciding whether that's the best strategy for you, especially given the availability of reporting cartel type activity, so your wage fixing, no poaching type arrangements, where you can get a reduction in a fine if you benefit from the leniency or immunity policies that exist in certain jurisdictions. So these are just some of the points that I wanted to raise. It is very topical in the antitrust world, and almost every month you're hearing of a story on this arising in different jurisdictions. And so I hope you found that interesting, and I will pass you on to Serena and Imogen.
Hi, so Imogen and I are going to speak about hot topics and horizon scanning, and I'm conscious of time. We want to leave some time at the end for some Q&As, so we will take you through these fairly speedily. The first point we're going to talk about is flexible working, and where are we heading now as we come out of the pandemic and people settle down, return to the office, but maybe consider that they don't want to be in the office all the time. This is, you'll probably have seen yourself, this has gained increased media attention and public interest. People want to read about it more because they are more interested in it themselves. There's more cases. And so it's important that your staff are probably aware of these kind of cases and starting to think about how they want to work as they go through into the next few years, now we're out of all the lockdowns.
So on to the next slide. The first case I wanted to talk to you about is on flexible working, is an NHS case. So Miss Dobson was a community nurse working for North Cumbria Integrated Care NHS Foundation Trust. She had 3 children, 2 of whom were disabled. She had, for a number of years, due to her childcare responsibilities, worked only on Wednesdays and Thursdays each week. She needed to help look after her children the rest of the week. In 2016, her employer issued a new rostering policy where all employees who are community nurses had to work flexibly. And that included working on the occasional weekend. Now that would only be no more than once a month. However, Miss Dobson said that she just couldn't work flexibly. She couldn't agree to the new rostering. She ended up being signed off sick and she issued a grievance. After a series of meetings, the trust decided to dismiss Miss Dobson and offer to re-engage her on those new terms that she had rejected. She refused to accept this new working pattern and she was dismissed on notice. She claimed the policy indirectly discriminated against her as a woman with childcare responsibilities, and she'd been unfairly dismissed. There were some other claims as well, but we don't need to go into those. At first, the tribunal concluded that her claim for indirect discrimination was failed because there was no evidence that she had been able to produce that the requirement to work flexibly, including at weekends, caused a particular disadvantage to women compared to men. There were some other female community nurses who were able to do this rostering. However, Miss Dobson appealed, and the AIT allowed that appeal. And in its judgment, it found that Mrs. Dobson did not need to adduce evidence that she was disadvantaged because of her childcare responsibilities. It found that women still bear the greater burden of childcare responsibilities than men. This can limit their ability to work certain hours. While things have progressed, the position's far from equal. And the childcare disparity has been accepted by courts at many levels for many years, and if it's relevant, it must be taken into account without the employee needing to produce specific evidence for that specific role. It's an important decision because it makes it easier to bring those types of indirect discrimination claims for childcare responsibility disadvantages. So if there's women who find it difficult to work certain hours, nights or changeable hours because they have fixed childcare routines, they can't work flexibly, then it's going to be easier for them to bring these types of claims for indirect discrimination. The next case, another flexible working case, which is Follows and Nationwide. Mrs. Follows, in this instance, she worked as a senior lending manager for Nationwide. She was on a home worker contract, although she did come into the office 2 or 3 days per week. This is well before the pandemic. She needed to work from home because she cared for her disabled mother. In 2017, Nationwide decided to reduce the number of senior lending managers, and that those that remained all had to work in the office permanently, no home working. The reason for this change was supposedly that there was a greater need for staff supervision. Mrs. Follows was told she was at risk of redundancy. She made it clear she wanted to stay. She felt her home working arrangements could continue. She did attend the office regularly. She had documented history of excellent supervision of the individuals. Now, Nationwide had too many volunteers for redundancy, but yet they still made Mrs. Follows redundant, even though she was clear she wanted to stay. She brought various claims, including direct and indirect associative discrimination on the grounds of disability. The tribunal upheld the claim of indirect disability discrimination by association. The criterion that Nationwide had applied was that all senior lender managers should work in the office. However, those with caring responsibilities for disabled relatives, like Mrs. Fellows, would obviously find it more difficult to comply with this criterion than those who didn't have those caring responsibilities. The tribunal found Nationwide couldn't justify this by showing it was a proportionate means of achieving a legitimate aim. Now, even though the Equality Act on its face of it doesn't allow these types of indirect discrimination for associative discrimination claims, the tribunal had relied in this instance on a European case. This decision is it's only an employment tribunal claim, so it's only persuasive, it's not binding. But these types of issues, as the more cases come up, as they become more public, employees are more likely to realise that these types of associative claims can be brought successfully. So it highlights the risks of when you're dealing not only with disabled employees, but also with carers of disabled employees, and you're on notice that they have that responsibility. And also another point, to be very clear about what the legitimate aims are when you're making these sorts of changes to working patterns, because this idea about needed for supervision didn't work here, because she had always supervised her staff perfectly well when she was working from home. I'm going to move on to Imogen now, who's going to look at the government consultation.
Thanks, Serena. So as Serena's covered, the landscape for flexible working is changing, and that's led to a government consultation about flexible working, which sets out 5 key proposals for reshaping the existing framework, which is set out on this slide. Before we go through them, I think one point that is worth mentioning from the outset is that despite the headlines you may have seen, there's no proposal to make the right to work flexibly a default right. Many of the newspapers jumped on that as a kind of an attention-grabbing headline, but it's not the case. So briefly running through each of the 5 proposals on the slide, the first one is to make the right to work flexibly a day 1 right. So at the moment, an employee has to have been continuously employed for 26 weeks before they can make a flexible working request, but the government's considering removing that eligibility requirement so that the right to make the request is a day 1 right. I think one potential issue that we can see here is that on day 1, an employee or an employer may not have experience of how that job works in practice. So the agreed flexible working arrangement could end up being impractical or unworkable, which obviously, if an employee has already been in the job for 26 weeks, it might avoid that issue. The second proposal is whether the 8 business reasons for refusing a request all remain valid. So currently an employer could only refuse a flexible working request for 1 or more of the 8 business reasons which are set out in the legislation, and the government's looking at whether those business reasons all remain appropriate. The third proposal is requiring the employer to suggest alternatives if they plan to refuse a request. So as I mentioned, currently an employer can turn down a request for 1 or more of the 8 business reasons, and then that's it. There's no obligation to explore alternatives, but this new suggested approach would require employers to look at alternatives, and that may help employers and employees find an arrangement which works for both of them. The fourth proposal is a review of the administrative process underpinning the right to request flexible working. So currently an employee can only make 1 statutory request every 12 months, and an employer has to consider the request within 3 months. But the government's considering removing that 12-month barrier and shortening that 3-month period for consideration. I think that one's an interesting one because on one hand, it's entirely understandable that employees' personal circumstances could change. They meant to make more than one request per year, but it's also balancing that with the potential burden for employers to be dealing with numerous requests, especially if they have a shorter time limit in which to respond to those requests. And then the final proposal is the right to request a temporary flexible arrangement, as the government believes that the ability to request temporary arrangements is underutilised by employees. So I think that it's fair to say that any changes as a result of this consultation are still a while off, but it does signal that changes are on the way, and we may see the right to request flexible working becoming a day one right in the not too distant future. So the second topic to cover is hybrid working. So as I say, we've spoken about flexible working requests, but even if employees don't make a flexible working request, then hybrid working is becoming the norm in many workplaces. Now, there's obviously lots of advantages to hybrid working, but there's also a number of potential pitfalls that need to be considered, one of which is the potential for discrimination claims if those who work remotely are treated differently to those who work in the office. So in those circumstances, there may be scope for an indirect discrimination claim on the grounds of sex, for example, because as Serena mentioned, the statistics show that women are more likely to work remotely due to childcare responsibilities. Now, there's a few particular issues to consider which are set out across the bottom of the slide. I won't go through all of them, but for example, if managers are allocating more work or the best projects to those in the office, then that may disadvantage certain groups of employees who are working remotely. With events, you should consider whether it's possible or appropriate to run both virtual and in-person events to ensure that everyone is included and feels part of the team. And I think behaviour is also a key one, as during the pandemic we saw inappropriate behaviour adapting to the remote environment. There was an increased use of inappropriate emojis, GIFs, instant messages, for example, and as people adjust from long periods of home working to being back in the office at least some of the time, it's important to keep behaviour in check, and it's worth setting the tone and re-establishing expectations and boundaries from an early stage. Moving on to the next topic, which is the menopause. This is becoming an increasingly prevalent topic. You may have seen the headlines last week that Sadiq Khan has announced that City Hall staff are going to be permitted to take menopause leave, and he said that he hopes more workplaces in London will follow suit. You may have noticed more media attention on the topic generally as well. I know that Davina McCall's given an interview about her experiences recently, as has Karen Brady. And there's also an increased focus from a political standpoint. So there's been a number of consultations. For example, the Women's Inequality Commission recently launched an inquiry. And as part of that inquiry, there's a discussion as to whether the menopause could become a standalone protected characteristic at law, in addition to those 9 protected characteristics that Richard mentioned earlier. So it is something that employers need to be aware of. It does expose them to a number of risks, some of which are neatly illustrated by this case study on the slide. So if we run through the case study, an employee gives their manager, sorry, could you go back to the previous slide? An employee gives their manager a doctor's letter stating that they're going through the menopause and this could affect their concentration levels. The manager undertakes no further medical investigation and does not refer them for an occupational health assessment. The employee is dismissed following a final warning for poor performance, and those actions were in breach of the performance management policy. What are the key risk areas there? And this particular fact pattern followed an employment tribunal case, and in that case the employee successfully claimed both unfair dismissal and direct sex discrimination. And although that particular case only concerned those 2 claims, you could see how it could have given rise to other claims too. So, for example, potentially disability discrimination if the symptoms were severe enough to qualify as a disability under the Equality Act, age discrimination, as the menopause typically concerns people of a particular age range, or breaches under health and safety legislation for failure to undertake adequate risk assessments or to provide a safe working environment. So I think for our part, we're certainly seeing a rise in employment tribunal cases referencing the menopause, and as a team I know we've drafted a number of menopause policies over the last 12 months, which prior to that isn't something that we regularly saw. So it's definitely something that employers and managers should be aware of and keep an eye on developments in that particular sphere. I'm going to hand back over to Serena to touch on COVID.
So COVID, we think we've got rid of it. There are a few just key milestones on the sick pay regime. As of today, the statutory sick pay rebate scheme has closed. And as of next Thursday, the COVID-related sick pay rules that were brought in 2020, which say that you can get statutory sick pay from day one if it's COVID-related absence, they are going away. So sick pay will kick in from day 4 as for other illnesses. And then on the 1st of April, there's the end of free testing. What the government's effectively doing is leaving it up to employers how it wants to deal with employees who have absences for COVID. Do you want to pay them sick pay alongside any other illness they might have, or do you want to encourage them to stay out of the office? Do you want to have policies about forcing them to work from home if they have COVID or they, might reasonably be suspected of it? It's all up to the employers, and as a result, inevitably there will be some issues, and different employers will take different approaches, and different employees will feel differently about those approaches. So just going to have to wait and see how it plays out. Where employers can have their staff home working, that's obviously the easiest scenario. So you don't have to have that risk of people coming into work to avoid dropping down to sick pay or even no pay at all. But we're just going to have to see how each employer and how the markets adjust to the new rules or lack of rules. I'm going to pass back to Imogen to talk about holidays now.
Thanks, Serena. Holidays, there's been a recent key Court of Appeal decision on holiday pay, and in that case the Court of Appeal for a worker who took unpaid leave because he was incorrectly classified as self-employed rather than a worker was entitled to claim compensation for unpaid holiday on termination covering the whole period of his engagement. Now, this decision means that if workers haven't been able to take paid holiday for any reason, they may have claims for a substantial amount of holiday pay per year, starting from when their engagement commenced and crystallising on termination. And this is likely to impact in particular the gig economy, where individuals say that they've been misclassified as self-employed and therefore haven't been able to take paid holiday as opposed to an employee or worker. So in terms of what employers should do now as a result of that decision, you may wish to consider auditing your workforce to identify any contractors who may claim to be workers or employees and to consider action going forward. And for those who are already categorised as workers or employees, the judgment makes clear that employees will need to be able to show specifically and transparently that the worker or employee was given the opportunity to and was encouraged to take paid annual leave each year. So it may be worth reviewing holiday policies and employment contracts in light of that judgment. The second holiday topic, which is on the right hand side of this slide, relates to the extra bank holiday that we're all looking forward to in June, if we are going to be allowed to take it. So whether an employee is legally entitled to take this extra bank holiday depends on the wording of their employment contract. So for example, if it says that they're entitled to 20 days holiday plus bank holidays, then they will be entitled to take it. But if it says that they're entitled to take 28 days inclusive of bank holidays, then it will be the employer's choice whether to allow them to take that extra bank holiday. And so in terms of what employers should do now, we'd recommend closely examining the wording of the employment contracts entitled to take that extra bank holiday. If so, then there's your answer. If not, decide whether the employer is going to exercise their discretion to give the extra day of holiday. And when making that decision, it might be worth considering what approach was adopted for the extra bank holiday for the royal wedding back in 2011, and whether practices will be consistent. Now, the fact that the extra bank holiday may have been given to employees at that time doesn't necessarily mean that the same approach needs to be adopted, but it may be something that long-serving employees raise or question. So it's worth being able to answer that if you're going to make a different decision. Hand back over to Serena just to finish off.
Thanks. Thank you. And I will just do this last slide very quickly. Now, the employment bill will eventually come. We were hoping it was going to come in 2021, but it didn't. Who knows if it'll come through this year. This is going to involve things like, as we said, making flexible working requests a day one right, some extra leave rights for neonatal care and for carer responsibilities. We will update you and make it very clear what the government is proposing when we finally eventually see the bill coming. So we will let you know exactly what it says and what the impact is. The government's response to the post-termination restrictions consultation is also awaited. We'll let you know when we hear from that. We don't know when we're going to hear from it. There's no sort of clues as to when the government's going to give its response on it. Are employers going to be made to pay employees for any non-compete period that they have to comply with after their employment has ended? How much would they have to pay? Will non-competes be banned altogether? We will let you know as soon as we know. And then on the sexual harassment consultation, the government's published its response on a consultation. It wants to have a new duty on employers to proactively prevent harassment. It decided not to include volunteers and interns specifically because it felt like they were covered already. It also wants to extend the time limit for Equality Act claims from 3 months to 6 months. It's all very vague. At some point, it might be worth starting to collate information and what your current policies and procedures are, but until we actually have some change to the law that we have an idea about what's actually going to come into effect, pause on that for now. We will again let you know as soon as we actually know something definitive. So I'm now going to hand over to Anne for some Q&As in our final moments.
Thank you, all of our speakers. Some real food for thought there, and I think some unexpected areas that perhaps HR doesn't always have front of mind, in particular, I think, coming from Marta Garcia on the competition front. We have a couple of questions which I think we have time to cover very quickly. The first actually is one for Serena, which is, given all the COVID changes you've outlined and when they're all actually in place, if an employee tests positive but is asymptomatic, will they still be able to get statutory sick pay?
So I think it will all depend on whether they are actually well enough to work, and if they are happy to go to work and are being required not to come into work, and assuming they aren't able to work from home, then I think actually it's not a matter of statutory sick pay, because they're saying, well, I'm not sick. It's not a sickness absence. They actually should be getting their full salary. It's just a requirement for them not to work on that time. So, you know, a bit of a wheeze there to say, oh, I've got COVID, but I'm perfectly happy to come in. I think for probably most of our clients, they do actually pay full sick pay for the first few days, because it's a payroll hassle to change it. So actually, you can just require the employee to stay off, and it doesn't matter whether they're symptomatic or not. But I think that's going to have to be the right way, not to have employees in the office if they know that they are asymptomatic, because there's quite genuine concerns from other employees that they absolutely do not want to be working around employees who can spread it to them.
Yeah, I think that's absolutely right. One for Katie, on the data protection side. We've got this new concept of vexatious requests which can be refused. This question is wondering, when the DSARs are used as pre-disclosure, so before you have a tribunal claim, for example, could you call that vexatious and just refuse to answer it? So it's almost like in the High Court, of course, there's pre-action disclosure, and if you're trying to use a DSAR to the same effect in the tribunal, where you don't have the same rules, could you just say no to the whole lot?
I don't think the vexatiousness new test is going to go that far, but in that, you know, purely because something is being used as pre-action disclosure is probably not going to cut it. But what it will do, it could give more scope. It's all going to be in a very lawyer sort of way, case by case, isn't it? But I think what the new test, if introduced in its current form, could do is allow that context to be taken into account. And if, you know, in the context, it's obvious that the request is just being made to annoy the employer, or they're asking for historic or trivial information, and actually in the context, you know, it's because they're trying to say your systems are terrible, I want to sort of show you up for this, or something, there's some other kind of wider issue going on in the litigation, I think that might become relevant. But I don't think it's a sort of pre-action disclosure in itself is necessarily, as the proposals currently stand, going to be grounds for refusing. But yes, I suppose watch this space. Fingers crossed.
Yeah, so it sounds so we're not going to be, unfortunately, making much ground on that one, which is one employers often try to knock out requests on. I'm going to pose one final question to Richard, which has come through, which is, and the reason I'm asking is because it just happens so often. It's something we encounter a lot with different clients, which is, what should we do if an employee comes to us with a grievance or complaint about workplace behaviour, but asks us not to do anything about it?
Yeah, thanks, Anne. As you say, that's something that happens more and more. I think the short answer is you still need to take action. I mean, obviously, each case will need to be considered, but you're more than likely that you will still need to take action. Reason being, well, firstly, you will need to do so, but reassure them actually that you will do so, but in a way which you will do so in the absolute utmost confidence, and reassure them that it will only be disclosed to people on a need-to-know basis. But the reason why you should do so is that actually, if you don't do so, and then a similar issue comes to light later on with the same employee, or even with another employee making a complaint in respect of the same alleged protagonist, and it's certainly not going to look favourable on the employer if it comes to light this issue or a similar issue had been raised previously and they had not done anything with it. And rightly or wrongly, an employment judge simply won't give much credence to an explanation. Well, this issue was raised previously, but we were asked not to do anything about it. In the cold light of day, an employment tribunal, they will simply hear that, well, you were told about this issue before and you did nothing. So it is an extremely difficult position that employers are put in, or individual managers are put in, when this happens, and it does happen. It happens more and more. But I say, my view is most cases you will absolutely still want to take action, but I say you should reassure the individual that you will do so in a way which, you know, you will treat the matter with utmost confidence. And as I said during the talk, any individuals that you do need to involve in the process, that confidence should be stressed to them. And of course, you know, you'll be working alongside your HR teams as part of that. But you're right, Anne, it's certainly something that we see happening more and more, and it is a difficult position to be placed in.
Great. I appreciate we're overrunning a little bit, but there is a very interesting question which came for Marta, which I just wanted to put to her. If Marta, you can give us a quick roundup on your thoughts, and then we'll finish. Which is that one of our delegates has pointed out that Andrew Bailey at the Bank of England has urged businesses to refrain from increasing wages in order to keep inflation down, but does that conflict with the regulator's view on keeping wages down?
Okay, so I guess just to bear in mind, everything is a bit of a case-by-case analysis. So even though you might have an industry individual, you know, recommending a particular avenue or course, that doesn't necessarily give rise to a competition issue. What is most important that the regulators are looking at is if there is any form of agreement between competitors. So if, as a result of any statements made by Andrew Bailey, you had competitors in a particular sector getting together and then discussing wages, whether or not they increase or not, or what level they set particular types of employees, that could be considered problematic, especially if there was evidence to that effect. So Andrew Bailey urging that, when we understand the economic circumstances that we are living at the moment, doesn't necessarily raise a concern, but it's what happens following that, whether you do actually have competitors getting together or you have the government encouraging that sort of communication. Because what we have found in other industries is governments have encouraged that conversation, and that has led to issues where then the government has had to almost backtrack and issue what we call exclusion orders to allow competitors to discuss particular aspects that would ordinarily be considered problematic. So I hope that answers the question, but that is how I would consider that question that's been raised at the minute.
Yeah, really interesting. Thank you, Marta. I'll finish there. Thank you to all of our speakers for some really interesting sessions. I really enjoyed sharing this, hearing all the interesting thoughts that are coming out of various corners of our practice, and also in particular, thanks to Katie and Marta, our colleagues who specialise in the outside the employment sphere, but areas which touch on day-to-day life in HR as well. So thank you very much for listening. We really hope that our next session is going to be in person. We've missed seeing you. I'm sure you haven't missed the Stephenson Harwood coffee, but with any luck, we'll manage to improve the quality of that when you all come back into the office, which we hope is going to happen very soon. So thank you very much. Have a lovely day, everybody. Thanks.